Welcome to this webinar series on ethics and administrative justice. I'm Lawrence Sawson, Dean of Osgoode Hall Law School, and it's a pleasure to be a part of this collaboration between SOAR and Osgoode Professional Development. Today's topic, the Tribunal from Heaven, may or may not have been self-explanatory when you saw it listed. Some of you will be familiar with Margot Priest's work on the Tribunal from Hell and some cautionary tales in that regard that many of us have told and heard over the years. And we felt too rare are the occasions when we explore what tribunals can and are doing right, and the experiences, particularly of advocates and counsel before tribunals, are going to be our focus. And while we may take a sweetness and light lens on tribunals, the goal of this discussion is not just to point out those things that are working, but some of the tensions and dynamics and forces at play in tribunals from an advocate's point of view that can determine whether tribunals in fact succeed or not. And the Tribunal from Heaven is as much an aspirational goal as it is a statement of any particular reality. And to join us to share their perspectives on this topic, we have a stellar panel of experts with diverse and rich experience as advocates and people associated with tribunals from a number of perspectives. We're joined first by Ian Rowland, who is a founding partner of Pallier, Rowland, Rosenberg, Rothstein, LLP. And then next to Ian is Sean Dewart of Dewart Gleason LLP, and next to Sean is Ron Ellis, who is a well-known author, educator, lecturer, scholar, and of course, former chair and CEO of what is now WSIAT, was WCAT at the time, and many other roles. And what I'd like each of them to do, just before we dive into the discussion, is just spend a minute or two on their own background and perspective on the topic as a way of welcoming you to the discussion and again introducing a bit of where they're coming from. So Ian, let me start with you.
Okay, very briefly then, Lauren, it surprises me, but I've been actually practicing law for 39 years. And throughout that period, I've been counsel and independent legal counsel for and before a host of tribunals. I think if you categorize them, probably the largest category is labor tribunals of one sort or another, labor boards, arbitration boards, and various kinds of manifestations of employment and labor tribunals, and also in the health regulatory field, both as prosecutor, defense counsel, and again as independent legal counsel to the various colleges, several of the various colleges in Ontario that regulate professionals. So that's, I think, in a general context, most of my experience is there.
That's great. Sean.
So I've been practicing since 1986, however many years that is, and am uniquely unqualified, I think, to sit on this panel because most of my work is civil litigation. My experience with tribunals leaves me unqualified to sit on this panel because it hasn't been heavenly. I've done quite a bit of work in front of law side hearing panels and have views about them. I've appeared in front of regulated health profession tribunal, again, not the happiest of occasions. And then I've had one encounter at the Labor Relations Board with Ian. And that was ultimately a very, very happy occasion, I suppose, but not before the tribunal. So I don't have the qualifications to hold strong views I do, and the views I do hold are not, I think we'll find, entirely favorable.
Well, there's a difference between being unqualified and disqualified. So we will take your insights as welcome and look forward to them in a moment. But Ron, before that, over to you for a word.
Well, I've been practicing law for so long that I can't remember how long it is. My early experience with tribunals were similar to Ian's, with particularly the labor board, arbitration boards, and so on, as a management labor lawyer. So we have a little balance in that respect. My most relevant experience was, as you mentioned, as the inaugural chair and CEO of what was then called the Ontario Workers' Compensation Appeals Tribunal, where I was for 12 years. And since then, I have been a labor arbitrator, and then I went back to school for a PhD, and that dissertation turned into a book called Unjust by Design, published by UBC Press.
Oh, the order form is going to be part of the material,
Yeah,
so
yeah.
there's no worry about that.
Unjust by Design, Canada's Administrative Justice System. So you can tell from the title where I come from. I have to say, though, that many of my best friends are tribunal adjudicators, whose performance I have a high regard for. So there's a mixture of, some people do an excellent job despite all of the structural problems that they are forced to cope with.
Well, Ron, let's start with you on that note, and the question why we do focus on the negative. And I've been part of lots of different discussions involving advocacy before a wide range of tribunals, and in many cases, when I compare it to the response of advocates before courts, before other bodies, in substance, the differences are fairly fine-tuned. But there does seem to be this tribunal from hell ethos as people talk about administrative justice. It may be different expectations they bring. It may be the real diversity of that experience causes a bit of cognitive dissonance for advocates who are moving from one setting to the other. But there does seem to be a focus on the negative in tribunals. And is it appropriate? Is it something you've seen in your research?
Well, first of all, I'm not sure that we do focus on problems and deficiencies. We've had a very deficient administrative justice system for 5 or 6 decades, and it's got very little attention over that time. But if we do focus on problems and deficiencies, I would respectfully suggest is because there are many of that problems of that nature, and they are always with us. So, and when governments adopt sensible policies, as I think the Ontario Liberal government has in many respects in their appointments process, they do not do much in the way of advertising the change. You don't see an ad from the Ontario government saying that we have abandoned the use of patronage policies in respect of adjudicative tribunals. They may have abandoned them by and large, but the vast public, the people who deal with the tribunals, are not given any reason for confidence that that is the case. And I think it also stems from the fact that the government has this idea that, I'm talking about adjudicative tribunals, I have to say, and maybe I should make that point. Tribunal writ large includes regulatory agencies and adjudicative tribunals. The regulatory agencies are a different problem, and different considerations, different solutions. Mm-hmm. So my focus has always, interest has been the adjudicative tribunals, the justice system institutions. And so the problem is that the government still regards those tribunals as opportunities for public service by well-meaning citizens. The qualifications now are better, that are as laid out in the new legislation, right, and so on. But if you look at the Appointment Secretariat website, that sense of that they're looking for, they want people to come and give some public service. They're not going to pay them a competitive wage. They are not going to allow them to stay there for more than 10 years. And so there is this lack of commitment to an adjudicative process that is actually competent and professional.
So Ron, hold that thought on a point that's related to this issue of expertise of tribunals and how it's demonstrated, because I want to come back to this question of the generalist versus the specific. But just on this point, Sean, from your experience, I'm curious whether the deficiencies, and I read into your introduction, that's been part of your experience, were a product of the limited kind of mandates, the policy-driven kind of jurisdictions, or just quality and experience as an advocate with a hearing process per se? Because I think sometimes with tribunals, the two can mix together. Sometimes they're just such limited remedies or limited resources that an advocate can bring a frustration to it that isn't really about the process piece, but the pieces over which tribunal members, for example, have very little control. And then sometimes it is just a uneven experience with the hearing and the tribunal.
Well, there's no doubt that the logistical differences can make a difference, but just to sort of take a step backwards, I don't really agree respectfully with the premise of the question. I mean, I don't think the ethos is that tribunals are from hell. And on the contrary, I was schooled both here at Osgood, really pleased to hear, and when I did a graduate degree in the UK, I was told about the glories of tribunals and the need to recognize their expertise and the need for curial deference. And there obviously had not been sufficient curial deference in those days, but the pendulum has swung so far the other way that they can get away with anything. And to my mind, in a sense, you know, we talk about them, or to the extent people denigrate the tribunal system, it's because there's no effective oversight, or there's insufficient, that's obviously an exaggeration, but there's insufficient curial oversight. And I don't think any adjudicator, with very limited exceptions, should ever sit on an important decision and not be subject to some form of review.
You know, I think that's an interesting perspective, and maybe, Ian, I'll turn to you on that as well, having argued for deference in a variety of settings and seen both sides of the coin. Where are your perspectives?
So I've argued both sides of that, as I'm sure Sean has, both for deference and against deference. And that pendulum is always swinging. It actually seems to be swinging slightly the other way to a little less deference. There's some cases out of Saskatchewan recently, that Saskatchewan Court of Appeal, that afford quite a lot less deference than one would expect to an administrative tribunal. And the courts are going to move back and forth on that. Those cases, you know, tend to be very much fact-oriented. The particular case often drives the adjudicator, in this case the judge or the appellate court, to a decision that may, as its consequence, look like there's less deference or more deference. But certainly, I think the problem around all of that really focuses on two issues, two really fundamental issues with administrative tribunals. One is adjudicative expertise, and the other is subject matter expertise. And the complaints we hear on both sides, that is the adjudicative expertise, which is often the reason that the courts overturn a decision,
Right.
Isn't there sufficiently to properly conduct the hearing, the administrative tribunal hearing. The other problem, and judges suffer from this as well, is the lack of subject matter expertise. You know, judges, the generalist judge in today's courtroom is really at a disadvantage in many cases, because the judge can't really very well or very extensively grasp the subject matter. It's complex. There are some very complex areas of litigation. And so we face those two issues, I think, at administrative tribunals, both the need for subject matter expertise and the need for adjudicative expertise. And it's not easy to combine those two in the way in which we've structured administrative tribunals.
So let me press on that point just for a moment. I'm going to come back to each of you for some inspiring moments you've had in front of tribunals that's more concrete. So start cogitating on that. But I want to pick up on the expertise question first, because I think Ron introduced this idea, and I think helpfully you're distinguishing between the adjudicative piece and then the subject area piece. But how does a tribunal demonstrate expertise in either sense? In other words, should we be assessing them based on the success or failure on judicial reviews? Is it the reputational sense among experts in the bar that this is a tribunal to be taken seriously? Is it looking at appointments and their qualifications at the outset, and just a quick reaction from each of you on this question of what do you look for when, as an advocate, you're coming to grips in a complex, specialized area with the tribunal's expertise.
Want me to start on that?
You start
So
on that.
let's start with adjudicative expertise. Here's the struggle, is that a lot of tribunals don't appoint people with adjudicative expertise, which really are trained lawyers who aren't just trained as lawyers. We're not talking about solicitors, people who are real estate lawyers or corporate lawyers. We're talking about people who are trained in adjudicative subject matter, how to properly conduct a hearing. And those are, in background, those are basically litigators. And then there's the subject matter expertise, and often some tribunals don't have any subject matter expertise. They just hope the person can pick it up. Lots of tribunals have only subject matter expertise and no adjudicative expertise. And it's really the combination that's needed to have an effective tribunal.
But isn't it the case that anyone with subject area expertise or with a general background, if it's a credibility assessment kind of tribunal, can receive the training and exposure on the adjudicative front? And we certainly, through SOAR and bodies dedicated to training, put a lot of stock in that sense, as does the National Judicial Institute, that coming into a judicial career from a legal career requires additional training as well. Is that all, this idea of legally and non-legally trained people coming together in administrative justice not quite cracked up to be the kind of vibrant mix we think it is?
I think it's the other way around.
What do you think?
That not everybody can be an adjudicator, contrary to common belief. You need an appropriate temperament, an ability to empathize, to step into each party's shoes and understand their case sympathetically. And not everybody has that ability. So if I'm staffing a tribunal, I'm looking primarily for the adjudicative qualifications along those lines and demonstrated by actual experience ideally. The expertise side of things is something that I think you do pick up. You've got to see, you're working in a specialized environment in which all your colleagues are working on the same thing. The training is possible, and you do pick up that expertise after you working with the people who know about it and writing reasoned decisions about it. So, and the problem with, I have a quarrel with the Adjudicative Tribunal Act in that it requires, one of the qualifications is knowledge in the field that the tribunal is working in. But you bring who are typically advocates who have been working on one side or other of that street. When you bring them into the adjudicative position, you have this problem that's been referred to, of having an engagé. I don't understand the French. In other words, they come with an established and deeply rooted point of view on that subject. And A, they have trouble being a neutral adjudicator as a result of that, as a matter of fact. And B, they have a huge problem with convincing the parties who are appearing before them that they are neutral.
So Sean, how do you reconcile that in your own thinking?
Well, I guess I would agree that fundamentally it's a question of temperament, and that any adjudicator should have a quote-unquote judicial temperament. And it is hard to measure for that in advance. But I think a legal training and education does help. And by that I mean, I don't think you need to be necessarily a litigator there's lots of great judges and adjudicators who've come out of a solicitor's practice, but they have a judicial temperament by reason of their legal education. And so first and foremost, and I'm sure this is a very unpopular thing to say and maybe perceived as quite elitist, but I think first and foremost, there's a lot to be said for having a trained practicing lawyer, not necessarily a litigator, in charge of the adjudications. And in the cases where you don't, and very, very limited experience here, but what happens, for example, in this regulated health profession tribunal that I'm thinking of, they end up either captive to counsel to the tribunal. So effectively, that's my adjudicator, counsel to the tribunal. I have to try and win him and her or her over. Or that they end up making just grotesquely unfair decisions that aren't based on the evidence, but on their own standards, which are of course perfect, and they don't really have the temperament to weigh and assess evidence and to consider things in the context that Ron was describing.
Oh, there's a view, though, of the Heavenly Tribunal, again, always keeping in mind the distinction, from a heavenly court. Heavenly court is a place where you expect to find the legal expertise because that's what the adjudicative process has been structured around. Arguably, in the Heavenly Tribunal, it's the mix of both having adherence to fairness and a transparent process and things that we associate with those rule of law values for sure, but also a kind of innovative thinking outside legal expertise on what kind of dispute resolution might work for a particular subject area. And in some cases, I've seen legally trained members having to unlearn some things from law school in order to open up a space for a different approach to dispute resolution, that not all hearings need to look as formal, and in a sense, asking litigators the question to, some hammers, everything looks like a nail. So if it's outside the comfort zone of a litigator, it's going to expose potential inconsistencies, potential unevenness, but also creates new spaces.
Can I give you an example of that opening up?
Yeah, I'm looking for the inspiring example, so let's hear yours.
Well, I had two experiences early on in the WCAP proceedings when we were feeling our way. One was this is workers' compensation, and one was an appeal. An injured worker was appealing, and for reasons I no longer remember, it was very important to get the sequence of his appearance before various medical doctors and experts and so on. So he was testifying, and he was unrepresented. He was sitting at our table where we were adjudicating this, and he was going through and he'd say, and then I went to so-and-so. And his wife was sitting in the audience, and she jumped up and said, no, John, that was before Christmas. We went there after. Oh, John says, that's okay, that's right. And then we went on a little further, and the wife jumped up again and said, no, you got that right. Finally, the panel said, Mrs. Brown, why don't you come up and sit beside your husband? And we swore her in, and the two of them sat there and went through the medical reports and records and got them all straight, and it took about 3/4 of an hour, and you could never question the credibility of the thing. It was the first hot tubbing of witnesses on factual issues.
But it worked.
I think that worked. It was wonderful, yeah.
And that flexibility to, in a sense, not be unduly constrained by a set of rules that wouldn't have fit the circumstances is one way of creating that
The other
space.
example, if I may,
Sure.
was, I may have been the very first one, but we had a worker who had a decision from the board and was appealing it. And on the record was his statement, I forget what it was, but anyway, that X was true. And the employer was represented in a counsel, very experienced litigation counsel, cross-examined him and got him to say that Y was true. And it was perfectly apparent to the panel and to the litigator that X and Y were inconsistent with one another. He must have been lying about this or that.
Right.
Well, in accordance with the great litigator's traditions, of course, counsel did not ask him for an explanation, just sat down and waited to argue that the credibility had been shot, you see. And so we were a new tribunal committed to, and with a statutory requirement to get it right.
Right.
Right. And so I, turned to the worker and said, now, can I explain this? When you testified previously, you said X. Today, you said Y. It doesn't appear that X and Y can both be true. Do you have any explanation? Well, he had a beautiful explanation, which was perfectly understandable, and he won the case. If we had followed the litigation,
If you hadn't asked the question, in other words,
yeah, that's right.
It would have.
And the litigator, I may say, was extremely upset with us at that time. But
Well, let's.
there's still a hole in the
let's turn
with
to
that.
Ian on this, because he's never been upset and he's always been inspired. So it's a perfect segue to
So let me
your
say,
case.
Let me say a couple of things in response to you and to Ron. First of all, the issue of people who are expertise in an area. Ron's criticism is that if you've got a particular subject matter expertise as a litigator, as a lawyer, counsel to a party or parties or one side of a regime such as the labor relations regime, and you get appointed as a neutral, that you have that's hard to be acceptable to the community. I haven't found that experience at all. In fact, the labor board's the best experience, in which every vice chair or chair that's been appointed to the labor board has come from the labor community, either acting for management or acting for unions.
But Ian, isn't it true that when those appointments are being made, that both communities are consulted before the vice chair is
More or less.
appointed?
I mean, you know, there is some sense of it. I think there's no formality in the consultation, but more or less. But to carry on, what you find practicing in the area is that those people who are appointed are very conscious of where they come from and are very careful to be as neutral as they possibly can be, and in fact sometimes sort of bend over backwards to prefer the opposite side a little bit in order to show their neutrality. Now, one of the best examples is our Chief Justice Warren Winkler. Warren Winkler comes from a management side labor firm. He's been one of the most enlightened jurists on the employee side that we've had in Ontario in years, in all kinds of cases. And yet his whole background is management. So, you know, we have examples of people who come from the community and yet are terrific as adjudicators.
So demonstrating expertise in an adjudicative sense in that context is about building credibility of impartiality, of not, in other words, being simply defined by a community of experts that you may come from, and being able to rise above the advocacy point of view that you may have started in.
Yeah.
And have you, Sean, seen that switching of hats from advocate to impartial, independent adjudicator with some bumps in the road, or can you think of times you've been inspired by the quality of impartiality you've seen?
Well, the Chief Justice Winkler, actually, I was stuck for a good example, but that would be a good example of someone who came from one side of the ideological spectrum and has handed down some of the most pro-employee decisions there are, and certainly in working with him in the Air Canada restructuring a number of years ago, he understands labor, he understands what works and doesn't work, he can deal with trade unions very effectively. But I posit that the reason for that is because he's independent, and we've been throwing around the words
right.
Neutral, independent, and impartial as if they're interchangeable, and they're not interchangeable. And so you get lots of neutral adjudicators at the OLRB, but and if they come from one side, is in large measure because they're trying to build up their credibility so they can start their arbitration practices. And so what you have is people striving to be neutral, which can lead at least to a lot of intellectual dishonesty in the decision-making process, as opposed to someone who's truly independent because he or she holds office for life and is accountable, in effect, to no one other than the Court of Appeal and the Supreme Court of Canada.
Well, let's take that point one step further, because if we're looking at the Heavenly Tribunal, it can't only be from the perspective of the advocates or even the users and the parties, but also the fact that these are created by governments, by legislatures for reasons. So a Heavenly Tribunal, I would imagine, has to also be one that fulfills that statutory mandate. And those mandates, as we know, have a policy dimension. If they didn't have any policy dimension, then these would simply be delegated to courts to handle. You wouldn't need a tribunal. Once you introduce a policy dimension, even if the policy is, fair adjudication in the context of that expert environment, is that a fair point to assess the tribunal from? In other words, if I'm elected with a mandate, it could be a pro-labor mandate, could be a pro-management or some other industrial goal that bears upon the jurisdiction of the board, and I want to appoint people who are going to be able to fulfill the legislative reforms, the other reforms we're putting into place, and I end up with someone who, in a sense, has changed their stripes from the time of appointment in the spirit of a good impartial adjudicator. and they're on a limited term, 3 or 5 years. Is that a legitimate reason for government to rethink in a tribunal context in a way that we would, of course, not have the chance to see in a judicial one because of the nature of those appointments?
Well, there's tribunals and there's tribunals, first of all, as Ron has pointed out, and generalizations are obviously extremely difficult. But it would seem to me, if you're adjudicating someone's rights, i.e. their right to return to work, that can't be informed. The result of that case can't be informed by anything other than the facts of that case and the applicable law. And so there is a policy-making role even for something like a labor arbitrator or the Labor Relations Board. But that has to be subservient at all times to getting the right answer. I would have thought of to straight rights administration.
Right.
And determining people's rights.
Although within the rights, within the law, are policies. I mean, there are lots of policies that are found in the law. That's what informs the law, is policy debates. For instance, the right to privacy.
Right.
That's a policy issue. We've in the labor arbitration world been debating that for years when there was no statutory right and there was no common law right. Now, the Court of Appeal has given us now a kind of common law right. But that's a policy issue, and that gets debated within the law. And so, in fact, most of the common law is policy. It's development of policy.
No, and you could argue the difference in the tribunal setting is so much of that policy is more explicit. It's set out in a particular statutory framework or through guidelines that government issues to fulfill something it's deemed in the public interest that then falls to the tribunals on a case-by-case basis to apply in a fact-driven search for the impartial, just result. But that line, when you're looking at the adjudicative expertise, is a very tough one, I know, for many members to navigate, and especially when the remedies and other powers of a board may be circumscribed, again, in service of a tribunal's goal. But I want to...
Let me just say about the policy issue, though. I think the important thing is not that tribunals have policies. They do. Every adjudicate body has certain policies. It's that we know what they are, that they're express, that they're open, so that we as adjudicators and the parties that go before them know what they're dealing with. It's the policies that are unspoken that are the problem.
Or I think from what Ron was saying earlier, the non-transparent way through an appointments process that one can undermine the goals that are set out in policy. And Ron, I want to turn to that for a moment because you mentioned your book earlier, and we wanted to canvass one of the proposals that has generated a lot of discussion in the community, and it speaks to your earlier intervention that about what can be and ought to be learned by someone entering the field, and that's a call for a professional designation that would be an element of someone's qualifications to then sit on at least an adjudicative tribunal of the kind you've been discussing. Can you elaborate on the rationale for that? And then I'll turn to Sean and Ian for a comment on whether it's a viable and heavenly way forward.
I don't advocate that nobody could be appointed as an adjudicative member of an adjudicative tribunal without being certified. What I think is that there should be ample opportunity for people to seek out that training and qualify themselves for those positions. And while I agree that knowledge of the legal system and how to conduct a hearing and so on is necessary, I do not agree that you have to be a lawyer necessarily. There is in the workers' compensation area, for example, a great numbers of advocates who don't have the legal training but who have had vast experience in advocating for employers or injured workers and who then qualified and some of them are on the WSIAT tribunal and were appointed to WCAT. So I don't say that. What I do say is that we need to agree that this is a professional activity, that this is not public service that somebody dabbles in for 10 years and then goes off to a quieter retirement, that this is a career that people can aspire to and know that they can make a career of it. that attracts the best competent people, that is competitive in terms of compensation. And having a school of applied studies in adjudication seems to me to be an attribute
So
of
Ron,
that.
though, how do you then justify the non-mandatory piece? In other words, if I look at it from the perspective Sean introduced of a right-seeking individual coming before a body, shouldn't that person, just as he or she has the right to an impartial adjudicator, an independent adjudicator, have the right to a qualified adjudicator in exactly this sense, someone who has had training on how to conduct a fair expert hearing?
The worrisome thing about certification is that it then stamps somebody as qualified, and therefore somebody who is entitled to be appointed to any vacancy where those qualifications are required. And it's that aspect of it that troubles me. I think you need a selection process, an appointments process, in which the user communities are represented, in which people are making judgments about the individual's judicial temperament and so on, and that allows you to. And I also am an advocate for continuing short-term appointment, renewable appointments, and I don't want the fact that somebody is certified to get in the way of being able to say, go away because you're not doing the job properly.
So let me get the comments from Sean and Ian on this. And again, keeping in mind that we don't have a similar designation for judges, and yet we have a much more diverse set of backgrounds coming to the adjudicative environment and administrative justice than the judiciary, where everyone has the same educational background at least, and similar kinds of experience and practice. But Sean, do you think that's a positive and workable step forward?
I think it's both. I think to go back a bit, I didn't mean to suggest that only a lawyer could be a qualified adjudicator. I agreed with the underlying proposition that it's a matter of temperament, and I think legal training can assist people in developing the right temperament. I think legally trained lawyers are more likely to have the right temperament. There's lots who don't, right? And there's lots of them who are sitting as judges who don't have the right temperament. So it's helpful, and what Ron is proposing is more concrete and more direct way of training people to have the right temperament. You can, but you ultimately want to end up with a selection process that doesn't require it for the very reasons Ron says. I agree with that, but which does, in one way or another, find people who have the right judicial temperament, which doesn't necessarily include full legal training. And there was another point, but I forgot what it was.
So let me pick up on that.
Yes.
I don't think the three of us disagree a lot, although what I see is two kinds of tribunals. We have the tribunals like Ron's tribunal, in which you have full-time appointees. They hear lots of cases. They garner lots of experience. They're hearing cases weekly, daily, whatever. And whether they're legally trained or not, they usually come with some particular training, like SOAR or like the Federation of Health Regulatory Colleges of Ontario, that provide very good training. They come with training, and if they've got the right temperament, I mean, it doesn't work, as Sean says, unless you have the right temperament, no matter what training you've got. But if they have the right temperament and they get that training and experience, they're generally doing a pretty good job. And they're doing a lot of it. They're doing it regularly. The problem is the tribunals that are very part-time, that are people, they draw on people who only do maybe 2 or 3 a year at the most. And that's really a problem, because you can't, even with the training, you can't get enough experience to be really very good at what you do. It's like a surgeon or anybody else. If you don't do it, you're not actually going to develop much of a skill. And that's where we have the problem, certainly in the health regulatory area, where we have a lot of very part-time people hearing these cases with some very good training, but marginal experience. And they just can't develop the kind of familiarity and comfort and expertise they need.
So here's a question, though. If we're looking for people who are steeped in many cases in expertise in a particular subject area, and we want them to be full-time, as opposed to being able to combine a full-time pursuit in the area with part-time adjudication, then do we risk losing that connection to the vibrancy of the expertise in play? You get retired people or people who've essentially opted out of that world.
There's a better answer.
Okay.
And the better answer is California. You say, why? What do
We
they
can
do
all
in
go to
California?
California.
Well, it's
That's
sunny
what
and it's
is.
warm and...
It's fabulous. But what they do in California in these tribunals is they have an administrative judge who sits as chair of these tribunals, and then they have the experts, the subject matter experts, there as the other panel members, 3 or 5. And so the administrative judge who hears these cases, and if you transferred that to Ontario, you would have an administrative judge who's very good, an expert in adjudication, conducting panels. It could be the College of Physicians and Surgeons one week, the College of Nurses the next, the College of Psychologists the next, with assisting him or her, the subject matter experts from the discipline, from the profession.
Oh, that's very
and
interesting.
it works really well in California, and it's been there. It's been in existence in California for over 20 years, and I've actually encouraged people in Ontario to think about it, and no one's been listening. So here's my chance.
So I know this may be an uphill struggle with the three of you, the argument that there's a risk that we over-legalize these tribunals, and you know, the three of you from different aspects, you know, have pointed out the important attributes that come from, you know, consistent standards, adjudicative temperament, which won't necessarily have to be paired with a legal background. But do you worry about creating environments that replicate the more formal approaches, having an administrative judge or having more of the trappings of adjudication? Coming back to Ron's inspiring examples, they have in common this ability to step outside of that formal role. And Sean, you mentioned your experience has mostly been on the civil judicial side. Could you be persuaded that there is a set of just outcomes, in fact, that will have to have more flexible rules of evidence or active approaches to adjudication rather than, you know, the passive neutral arbiter and so forth?
Well, absolutely, but you get, I don't think the dichotomy is as great as the question suggests. There's lots and lots of judges who are extremely informal, and you can be 90 minutes into a trial and the judge will say, I want to see counsel in chambers right now. And they get very informal and things happen, and you can end up with a just result in that case, for example. You can shorten the trial or settle the trial. It hasn't been great at it, but the courts have shown themselves to have some flexibility. And by contrast, there's some tribunals that make the courts look utterly informal. And I'm thinking particularly if it's rich people's rights involved, right? If it's a physician or a lawyer or something like that, it's like the court of the Star Chamber. It's so formal. And so as I say, I think the suggestion that, you know, there's sort of informality or the potential for it on one side and none on the others tends to be wrong. I think obviously Ron's stories are very inspiring. And you can tell just from his telling the story that with the husband and the wife, they got to the short answer quite efficiently. But it does cause me concern that when we're dealing with poor people's rights, social assistance, for example, or something like that, or workers' compensation, we're far more likely to walk away from the formalism, which, you know, is in this context is a pejorative word, and to go for efficiency. So I think there's a lot buried in the question. I promise I'm not making this up. Before Ian mentioned the example from California, that's what I was going to propose, is that you have, instead of the model we have now, where the physicians, or whatever it is, are conducting the hearing and deciding the fate, and a lawyer is on the sideline, you know, providing advice to the tribunal about the proceeding. You want to flip that. You want, whether it's a lawyer or not, you want a trained, qualified professional adjudicator deciding the case, and as a resource, you want him or her to have access to the scientific or medical expertise or whatever it is.
So there's a way to combine them, in other words.
And let me tell you a little bit about the California model, which I think really recommends it, is that the decision, the substantive decision, isn't made by the adjudicative judge. That's made by the fellow practitioners. If it's doctors, by the doctors who sit on the panel. They make the substantive decision. He assists them to write it, to work their way through properly to get to the result. But he or she, the adjudicative judge, isn't the decision maker. He or she's the decision maker on adjudicative issues. Is this evidence permissible or not? Those sorts of things. But when you talk about the substantive decision, that's left to the people who are the fellow practitioners, the professionals.
So let me come back to Ron on a related point about this informality and what's often called the culture of a tribunal, especially where there is a group of representatives or advocates who are appearing frequently, or a group of parties who are often before the board, and you could think of regulators in this case as well, that are characterized by this relatively informal culture, because everyone knows each other, trusts each other, and in fact it's come up in recent jurisprudence about reasons in a labor board. If everyone in the room who knows about labor would understand it, is that good enough, or does the person who knows nothing about labor need to be able to read this and make sense out of it? So Ron, you've been a part of tribunals, particularly the WCAT experience you've drawn on that had a very strong culture in that sense. Do you see a connection between that kind of culture, trust, leading to a kind of informality or collegiality among the communities of interest, whether parties, advocates, decision makers? And is that part of a heavenly tribunal, is building that culture of mutual understanding or trust from all the parties?
WCAT had the big advantage, in my view, that it was tripartite. So it sat in panels of 3 with a so-called neutral vice chair and a worker member and a employer member, representative. And I have great regret that we're gradually just going away from that because of the budgetary.
And we're to single decision makers and so forth.
Going to a single decision maker. And I would distinguish between the expert knowledge of somebody like a doctor about, the medical issue in the case, and an adjudicator who understands the context out of which the dispute has arisen. And with the tripartite board, we had a culture in which both the work and employer members would, at the point when we got to the decision-making, would take their partisan hats off, and they would contribute to the debate that led to over 95% of our decisions being unanimous in a tripartite. But what they did contribute, and which made the decisions much better in my view, was the worker member understood the workplace context in a way that the neutral vice chair has never put on a pair of work boots would, and the employer member understands the management context and concerns in a way that nobody else would. And those two contexts being part of the culture in the decision-making room contributed immensely to the quality of the decisions. And those debates were wonderful. And
in terms of formality and informality, I agree with Ron on that. I think it's having subject matter experts on your panel, people who are really knowledgeable of the subject matter, is incredibly valuable. In terms of the formality, though, the formality, informality, I think it depends really on the nature of the tribunal. And if it's parties that are appearing regularly before the tribunal, and they're comfortable, as you described, and they're there all the time, informality is fine. It works well. And everybody understands the nature of that informality. If, on the other hand, you have the worker, in Ron's case, who has never been there before, informality isn't a good idea, because the worker doesn't understand that. The individual who's come before the tribunal for the first time doesn't get what's going on in that informal exchange and feels like an outsider. And so when you have people who come to the tribunal really for the first time as a party, you need a level of informality that doesn't create the sense that they're in some sort of club that they're not a member of.
In other words, not having an exclusionary sense of...
Not to stop short of chumminess.
Mm-hmm. Yeah, and certainly, Sean, from a cultural point of view, having been before professional bodies, there are archetypes in some sense of what that, not necessarily chumminess, but that inside the beltway kind of thinking can produce. Have you seen that cultural aspect at work?
No, to the contrary. As I was saying a few minutes ago, I've seen the reverse. And so the Law Society hearing panels, which is the one I'm most familiar with, is rigidly formal, rigidly formal. And it almost runs like a criminal trial.
Right, so that's the hyper-legalized
They
approach
do
to administrative
hyper-legalize it.
justice.
Much more limited experience with other professional regulators, but I infer it tends to be very much the same. Certainly, my favorite commissions or hearings held under the Police Services Act. It's like a capital murder trial. I mean, it's just absurd the way they carried on and the resources that are poured into them, over whether or not someone's getting a one-day suspension. So unfortunately, no, I don't see. I don't see the distinction, as I was saying a few minutes ago, between whether it's a court or administrative tribunal is actually the meaningful demarcation between whether or not it's formal or informal,
Right.
or what's appropriate in the circumstances.
All right, well, let's do this as we come to the last round of thoughts, and I want to ask you each to reflect on what it would take for a tribunal, in your estimation, to take that positive step forward to balance this discussion we've been having about expertise, impartiality. What's a concrete step that a tribunal can adopt, which in your view will make it more heavenly, assuming we can't all move to California just yet?
Well, that's the solution.
But something that can be adopted, in particular, I'm thinking by the tribunals themselves, as opposed to changes that government might make or another outside body. What can the tribunal or members of a tribunal do in terms of a positive, concrete step forward that would better either demonstrate the kind of impartiality and commitment to expertise or commitment to the balance between those rule of law principles, policy principles, things that each of you has said are not really juxtaposed, but obviously the experience has been uneven with. So, Ron, beyond reading your book and adopting all the recommendations,
Well, if you want to go there, that's...
is there a single thing that jumps to mind as what a tribunal ought to be thinking of? They don't control the appointment process, for example, but they do control lots of other aspects.
Hopefully they
their life.
control the reappointment process, maybe.
Right.
Which I didn't mean to be frivolous, because if you have a tribunal environment in which everybody's reappointment is completely up for grabs, and you know that the chair's say isn't going to carry the day, then you've got a problem that is very difficult to cope with on many different levels. What you need is a collegial environment in which the decision-making is seen to be an institutional undertaking, an institutional decision-making, so that you can bring expertise from all corners of your tribunal and help out the people who don't have the expertise and arriving at decisions. Now, you have to respect the intellectual autonomy of the people who are actually hearing the evidence and so on. And, but you need to, like at WSIAT and at WCAT, we have a very well-structured draft decision review process in which people who have any doubt about their decision, and on some circumstances, new people are expected to produce their drafts to a review process of professionals who tell them, can advise them, have they identified all the issues that the fact situation seem to be presenting? Is this readable? Have you, do you know about this previous decision that
Right.
that's been that you might find relevant? And a collegial environment in which people wander around and talk to each other and are not afraid to go into the chair's office and say, I got a real problem here and I don't quite know how to deal with it, and so on. So that what you end, and a commitment to, budgeting reasoned, competent decisions. So you end up with a tribunal that is perceived by the user communities as competent, issuing congruent decisions, concerned to get it right, and doing it fairly, and so on. And I think you can't rely on individual adjudicators to
Right.
produce all that. You've got to have a corporate culture that is focused on getting it right.
So I'll call that the institutional sum is more than the parts
Yes,
approach.
absolutely.
And I think that's certainly...
And this is a problem I have with California, is that you move that person around and you don't have that culture in a particular tribunal.
All right, so we've got the esprit de corps institutional perspective. Sean, what for you would be the most positive, concrete step forward?
Excuse me. I'm hard pressed to think of a unilateral step that any given tribunal or tribunals could take, because the problems I perceive are far more structural than that. You know, as a concrete measure, it would seem to me to in order that we strive more towards independence and true impartiality as opposed to neutrality, which, as I've said, can lead to very cynical results. I think that the tribunal should not be permitting their members to sit as arbitrators at the same time, and they should be extracting undertakings from them, if this is even legally possible at the time of the appointment, that they're not going to subsequently sit as an arbitrator when their appointment is over. I doubt that is legally permissible. But I mean, that to my mind is the biggest single mischief that I've identified. And
so in other words, the avoidance of both explicit but also these kind of structural conflicts and role confusion among
and indeed
people
probably subconscious conflicts where, I mean, it's the same reason that as a commercial litigation lawyer, I have to be very careful about just regular commercial arbitration, because you don't want to pick someone who's going to, you know, be more inclined to favor McCarthy Tetra with 800 lawyers as opposed to me with far less work to steer their way. And sort of you have that, and particularly in the labor community, it's a pronounced problem. You have this, you have these neutral results that can be really very, very cynical in my view.
But also kind of alive to the lived experience or the realities at work behind the life of the individuals who are in these positions, and what's going to motivate them and what's going to create incentives to better or worse conduct at the end of the day. And that seems to me a perspective, you know, that's a nice counterpoint to an institutional lens, is that lens on the individual motivations and realities that you're right, you can only deal with at a structural level, but you have to be alive to what makes people tick in these settings in order to respond effectively.
I agree.
And Ian, from the institutional to the individual, where do you fall?
Let me just respond to Sean about the labor arbitrators first.
Sure.
Because I don't agree with him. The labor arbitration, process works very well because it's market driven. And if you're not acceptable to both sides, you don't get picked. Mm-hmm. And so you can't really, the consumers of labor arbitrations, which is the employer on the one hand and the union on the other, can't complain about the result because they've selected that arbitrator. And the reason they've selected them is they have confidence that arbitrator will be impartial, will provide a fair adjudication of the dispute. So I don't have a problem with that. I don't have a problem with people being neutrals at the labor board and also neutral arbitrators. They won't get picked as arbitrators if they're not acceptable to both sides. Going to your question though, what single thing can be done to improve the situation for tribunals generally? And let me make another suggestion, an institutional suggestion for many tribunals, not all, but I think many tribunals could do it. And that is, go to your community, go to your consumers. Once a year, I put it out, once a year, have WSIAC, the labor board, the colleges say, okay, all the consumers, who are the consumers? They're the lawyers, acting for the individuals, acting for the unions, acting for the employers. Come together and tell us what we're doing right and what we're doing wrong. Let's have a forum. Let's spend a day talking about it. Invite them there and get the feedback you need. And if we're doing something well, let us know. And if we're not doing it very well, let us know that too and how we can improve. And they don't do that. It's all a one-way street. We're all consumers, but they're not inviting us to tell them how they can do it better.
No, I think that's extremely helpful as a different perspective that we haven't spent a lot of time on, but is critically important, especially to the pathway to heaven that every tribunal seeks. And I think it's been a very constructive but also hard-headed look at the topic, which is exactly what I know the viewers were hoping and expecting. So let me just conclude by thanking Ian Rowland, Sean Dewart, Ron Ellis for sharing your insights, and we're looking forward, in the spirit of the last comment, to feedback and commentary from you on the various topics we've covered, and we'll look forward to responding to that. And again, it gives me a chance to thank the collaborative leaders of SOAR and Osgood and the whole production staff that make these webinars possible for their hard work. And until the next occasion when our paths cross at a webinar soon, we're adjourned, and thank you again for your time. Are we okay on time? All right, we missed a couple of questions, but...